Good afternoon, everyone, and thank you for coming. I'm Jacob Levy, the coordinator of the Research Group on Constitutional Studies, which is a unit of the Jan P. Lin Center for the Study of Freedom and Global Orders in the Ancient and Modern Worlds. RGCS brings together scholars from across the university primarily in law, philosophy, and political science, who study the fundamental institutions and structuring norms, legal and political, that make up the foundation of social orders. It involves scholars at all levels from the university, faculty and postdoctoral fellows, a fellowship of graduate students, of doctoral students who share office space in our building in Farrier Hall, and a student fellowship made up of undergraduates and master's students, the RGCS Charles Taylor Student Fellowship, that meets every week through the school year, except in the weeks of these lectures, for a dedicated reading group this semester on Karl Marx's Capital. The RGCS lecture series brings leading scholars to McGill from across the social sciences, philosophy, law, and neighboring disciplines, and asks them to present their research in progress on the values, institutions, and principles that structure a free society, and to do so in a way that is broadly accessible to our community, which includes a substantial proportion of students, on the principle that excellent researchers are very often also excellent teachers, and that if we ask them to do so, rather than relying on the traditional distinction within university life about visiting speakers, where researchers travel to speak to researchers and other people who aren't doing leading research are invited to speak to undergraduates. We rather ask our leading researchers when they visit to speak in a way that will present their high-level ideas to our audience that includes a substantial number of undergraduates. And for some 12 years now, both our invited speakers and our student audience has risen to the occasion and the expectation. It's a real pleasure and honor to welcome to the RGCS lecture series Richard Bellamy. Richard Bellamy is professor of political science at the University of College London, where he was the first to occupy that post in a department that he founded. He was trained at the University of Cambridge as an intellectual historian, but across his long and distinguished academic career, he has branched out substantially from that original orientation. His research comes in, I would say, largely four major streams. One is the intellectual history of Italian social theory since the Enlightenment. A second, his other historical stream, is the study of liberalism, especially in the 19th and early 20th centuries. The majority of his research over the course of, I would say, the last 20 years has been in analytic, political, and legal contemporary philosophy, with special attention to republicanism and to constitutionalism. And he's one of the leading scholars of providing normative analyses of the European Union and its governance structures. So a career that has spanned intellectual history, political philosophy, and the kind of comparative politics inflected institutional political theory that has marked the EU work, which corresponds quite nicely to the range of disciplines and subdisciplines that we welcome and involve within RGCS. He's a fellow of the British Academy, a fellow of the Academy of Social Sciences, a fellow of the Royal Society for the Arts, and a fellow of the Academia Europea. He's the author of 11 books, one of which, Political Constitutionalism, was honored with one of the most distinguished prizes available within political theory, the David and Elaine Spitz Prize of the Conference for the Study of Political Thought. He is the editor-co-editor of 30 more books. I'm going to speak about one of them at the conclusion, but before I quite reach that, I want to note that he has served for more than 20 years as the primary editor of the Critical Review of International Social and Political Philosophy, a very valuable journal in the field. His now nearly 20 years since his appointment at UCL were interrupted by 5 years when he directed the Max Weber program and was professor at the European University Institute, providing a really valuable infusion of political and social theory into an EUI social science community that has sometimes lacked them. So among those 30 books of which he is an editor or co-editor, one that's forthcoming is the Cambridge Handbook, not companion anymore, the Cambridge Handbook of Constitutional Theory, which has a close relationship in a variety of ways with what we do and who we hear from here at RGCS. 2 of the RGCS faculty members are among the contributors. Many of you were present about 6 weeks ago when Rainer Forst presented his chapter from that handbook to a packed room in Thompson House. Participants in our 2020 Constitutionalism in a Free Society, including Nomi Claire Lazar, have written for it, and previous RGCS lecturers have written chapters for it, one of whom is Turku Isiksel, whose lecture is, I believe, still the best attended in RGCS's history, and the author of the very first chapter in the volume was also the person who gave the very first RGCS lecture, just about 12 years ago, actually in this room, which is not the room that we most often use, Jeremy Waldron, whose analyses of constitutionalism and constitutional theory from a perspective that is oriented toward democratic participation and a kind of skepticism of counter-majoritarian and institutional entrenchment will be in some interesting conversation with what it is you're going to hear today. Please join me in giving a very warm welcome to Professor Richard Bellamy.
Well, thank you very much, Jacob, for that extraordinarily full introduction. I don't think I've ever had quite such a full introduction, which now sort of almost inevitably means it's going to be a terrible disappointment what I'm now going to give you. So I will try anyway to live up to my billing. This is a work in progress, which is part of a book called Defending the Political Constitution, which is in part a defense against the many academic criticisms of the book from 2007 that Jacob mentioned on political constitutionalism. But it's also an attempt, perhaps more importantly, to defend it from the many real-world challenges out there to this conception and to compare it with how legal constitutionalism has been able to cope with them. So this is where the chapter that I'm giving sits in the scheme of things. So it's one of the 3 chapters which restates the basic argument of the earlier book, restating it in a way which I hope can at least provide a plausible answer, not necessarily a convincing answer, but a plausible answer to some of the criticisms that have been raised. So in the earlier book, I had this deliberately provocative statement where I said the rule of law simply is the democratic rule of persons. And one reviewer, David Diesenhaus, who I'm sure is known to many of you here, in a review article of the piece in the Modern Law Review, simply sort of said, ridiculous. I mean, he liked other aspects of the book, but he just liked that, and most of his article, review article, was really defending his contrary view. And I'll come back to that in a minute. That statement seems to be counter to many assumptions about the notion of the rule of law, that it's an alternative to and a constraint upon the rule of persons. That it has a distinctive, the rule of law has a distinctive value, which coheres about, has something to do with the nature of law, and it shouldn't be confused with other values. And that the rule of law is, in a certain sense, in particular, the basis for and often threatened by democracy. So I'm hoping that I'm going to answer all of those 3 points in what follows. I'm also engaging in sort of 3 debates here, which there have been about the nature of the rule of law. So sorry, I was told not to walk. I naturally feel I've got to walk over here. So the first one is H.L.A. Hart and Lon Fuller, and they had a famous debate back in the 50s and 60s on whether Nazi Germany had such a thing as the rule of law, with Hart saying that it did, and Fuller saying that there was an inherent morality of law which was itself at odds with something as heinous as the Nazi regime. Then a sort of rematch in a different way of this debate comes with Joseph Raz there and Tom Bingham, Lord Bingham, who wrote what's often referred to as a popular classic on the rule of law. And Raz, who I will be returning to at some length in the rest of the talk, in a famous essay on the rule of law and its virtue, said, you know, people often put into the rule of law a whole series of substantive good things. They talk about how it must incorporate, in particular, a fairly extensive set of human rights. And he argued that's to confuse the rule of law with the rule of just law, the rule of good law. And I'm just interested in the value of ruling through law in a particular kind of way, understanding law in a certain kind of way. And that, he ventured to say, agreeing with Hart, is compatible with quite heinous regimes. And Bingham, in a sentence which sort of critics, defenders of Raz like to quote, sort of says, well, there is a certain logic to Professor Raz's argument, but surely nobody would want to hold that view in reality, even if it is logical. And so he represents another view which I'm going to criticize. And then finally, we have Matt Kramer, a legal philosopher at the University of Cambridge, and his colleague, Nigel Simmons, also a legal philosopher at the University of Cambridge, now retired, I believe. Anyway, in a footnote to chapter on the rule of law, where I more or less, as I to some degree do now, followed the Hart, Raz, Kramer line. I sort of said, well, if you want to read an up-to-date account of this debate, there are the many exchanges between Kramer and Simmons that have gone on, and I'm on the Kramer side here. And I got, when the book was published, a huge parcel, because this was still in the days when law journals produced printed copies and off-prints. And it was the collected works of Nigel Simmons against Matthew Kramer, with just a note sort of saying, I've read your book and footnote, whatever it was, and clearly you have not read all of these. Anyway, I showed the current paper to Matt Kramer, and he more or less did the same. He emailed me various copies of papers where he had criticized Simmons, because what I'm going to do in a way is try and drive a road between these two opposing views. I'm going to say that whilst I agree that the logic of Professor Raz is impeccable and one can conceive of the rule of law as being compatible with the Nazi regime or whatever, nonetheless, the very processes which constitute such a system are going to be unreliably present within non-democratic regimes. And if one wants the rule of law, one needs processes that inherently sustain the rule of law. And I'm saying that those processes are democratic in character. So it's the processual character of the rule of law that I want to emphasize. And I think when one does, even though it's present in all of these thinkers, it moves you somewhere in the middle between them in a way. So the rule of law as the rule of persons. Well, this quote comes from Jeremy Waldron, in fact, and his Stanford Encyclopedia of Philosophy article on the rule of law, where he says, you can no more law can no more rule us by itself than a cannon can dominate us without an ironmonger to cast it and an artillery man to load and fire it. So at one level, law is an artifact of human invention, as it were, and its application requires human institutions. There have been attempts by Hayek in particular to try and suggest that one can have the rule of a kind of natural and conventional law which emerges spontaneously. But even that, as we'll see, requires interpretation and therefore ends up raising all of these issues that I'm going to talk about of being ultimately the rule of persons. But what, as I've just said, the issue that I want to raise from all of this is that the processes by which the law is cast by the kind of legislative ironmongers and fired by the executive and the judiciary are ones that require certain kinds of democratic characteristics. So I start my sort of move towards this conclusion with what I called the Hobbes challenge. And for those of you, I should say, I'm going to use a number of thinkers now, not in a historical way. I'm not suggesting that what I'm giving you is a kind of genealogy of the democratic account of the rule of law. Rather, I'm using these thinkers as sort of ways of signposting a certain type of argument. And so I start with what I call the Hobbes challenge. And Diesenhaus's review article is called How Hobbes Answered the Hobbes challenge. So if you really want to get into the Hobbesian aspect of it, then you can read that. But I'm not going to say any more about that now. So Hobbes, his challenge was this. He said that all laws need interpretation. And we will differ in our interpretation of what the law is. Therefore, the rule of law requires a sovereign ruler. And if you ask, by what rule does the sovereign rule, then you're just going back on an infinite regress. So to avoid that, you've just got to accept that it's that person who's been covenanted by people in order to be the ruler rules from henceforth. And you actually destroy the rule of law if you question that sovereign position. So the rule of law is the rule of a sovereign person on this account. But that has, in the stark form that Hobbes gives it, it involves a certain problems. One is that quote there, law is but the word of him that by right hath command over others, suggests that law could simply be arbitrary commands. And as I mentioned earlier, one of the things that the people like Raz on the one side and Fuller on the other are agreed on is the rule of, when people talk about the rule of law, they're talking about a certain kind of entity which has law-like qualities and can be distinguished from simply a command. And then you have the issue of how do you define who has the sovereign right without raising these issues again. So the first issue is the one to do with, what distinguishes a law from a command, and Fuller, Raz, and all of the others, they tend to sort of say, well, you can tell what is law by virtue of it possessing certain properties, and I've listed there the properties which are that Fuller puts out and that most of the other people adopt or adapt in various ways. So it's something which is general, it's prospective, it's intelligible, it's followable and predictable. So once law is laid out, you know where you stand with regard to it. And for those properties to exist, it's not simply that the law must be framed in a certain way. There also has to be a certain procedural regularity in its application, so that, again, one knows that this law applies to all of us. So other people, you can rely on other people operating in a reliable way with regard to this law. Think of, the rules of the road, as it were, the traffic rules. They depend on the fact that not only you think that in Canada, unlike the UK, you drive on the right, but everybody else thinks that. And that's how we coordinate our activities with each other. And that and that the authorities think that too. You won't find yourself up and sort of say, oh dear, I'm afraid you're up against this judge who's a notorious left-hand sider. That everybody will be, that they'll also operate in this way. But all of those things can pertain, and yet the rules be hideous and evil in their character. So you can have rules about particular religious groups, like the anti-Semitic laws of Germany, which are impartially and regularly pursued by the authorities, and say, according to someone like Raz, that the rule of law holds, even though the content of the law is thoroughly evil. And Raz goes further in a I think a deliberately provocative part of his essay on the rule of law and its virtue. He says, it may even be the case that a non-democratic legal system of a tyrannist kind, which denies human rights, poverty, racial segregation, sexual inequalities, into all of those things, and yet it upholds them more proactively and more consistently than the laws of a just democratic state are. And he says, we could say of that country that it performs, it excels in its adherence to the rule of law, but that's because the rule of law is only one desirable quality. It fails dramatically with regard to justice and democracy and other important qualities. But then the question I want to sort of raise is that necessarily the case? Is it going to be the case that a tyranny which is in its makeup tyrannous and concerned with the power of those in charge to pursue their evil ends, which include enhancing their power and domination over other people, is that going to be a system which will always and consistently have reasons to pursue this in conformity to the rule of law? Hobbes says there's an instrumental argument for that if you want your country to flourish, so that commerce can go on, trade can go on, then you have a reason to promote the rule of law in a consistent way. And some people often raise a sort of what I've come to think of as the Singapore objection to me. They sort of say, well, you say, as I'm going to say, that you need democracy in order to have the rule of law. But Singapore has a pretty good private and civil law code. It just lacks a whole set of political rights. It's not a democratic regime in the full sense of the word. And I would say that the reason for that parallels in some respects, though not all, the incentives that you get in a democracy, namely that it's a tiny city-state dependent on world trade. It has no resources other than its favorable trading position. So it does have that instrumental reason. Its very existence depends on providing a system of reliable private and commercial law for people to want to be there. But for many tyrannies, that is not the case at all. And it's in those cases that I really want to, those are the central cases, in a way, that I want to deal with. Because you could sort of say, well, the Singapore regime is to some degree piggybacking on the fact that there are powerful democratic economic actors in the world with which it has to engage. But those regimes which have natural resources and therefore are not so dependent tend to have betray this instrumentality all the time. Think of China, for example, particularly under Mao and with the Great Famine, etc. So that then brings me to the issue of who rules So I agree that you need something like law to coordinate activity, and but I'm disputing that the right to rule can be, in a way that will maintain the rule of law, can be associated with a tyrannous regime. And that leads to Bernard Williams has challenged Hobbes in a very Hobbesian argument. He accepts Hobbes' argument that in order to ask questions about justice and rights and the nature of law, you need to answer what he calls the first political question, which is to have a sovereign ruler capable of defining for all of us what law, justice, rights mean. Otherwise, our debates will go on, and worst case scenario, it'll be the person with the most might who determines what is right. But, so you need a sovereign entity which has these qualities of finality, supremacy, and comprehensiveness, i.e. they can close the debate down. But it can't be that you create such a ruler and still stay in the state of nature. That's the point of the Locke quote that I had on the previous slide. Because that's not answering the first political question. It means that we're still in the state of nature. We're just dominated by some big bully into doing, who's grabbed power in order to put us in that state. So to get out of the state of nature, we need a form of governance which meets what he calls the basic legitimation demand. And he's a bit vague on what that actually means. And what I'm going to say, it means a form of democracy which in it has the processual qualities we associate with the rule of law, that is, that it's a general, impartial, equitable form of governance, and that has an inherent and intrinsic, as well as an instrumental reason for ruling in ways that persist in having those qualities. So they aren't just formal qualities, they become substantive qualities. And you only can keep having the formal qualities if you have the substantive qualities which are impacted within this system. And just to say, I mean, this is really the point where I differ from someone like Matt Kramer. Matt Kramer, in his book on the rule of law and an earlier book on legal positivism, he makes a distinction between what he calls the juristic conception of the rule of law, which is rule of law lowercase, and uppercase rule of law, big R, big L, which he calls the liberal democratic conception. He accuses me of not making this distinction. But my argument is that the juristic conception only pertains within a liberal democratic framework. And that's, so as I say, that's my via media between the two positions. So, answering the basic legitimation demand, I see, as I've said, the argument then is, well, how is it that we can set up a sovereign authority which will have the last word and yet won't itself be simply a way of institutionalizing an outcome of the state of nature? And Rousseau, who accepts the Hobbesian need for sovereignty, takes up that challenge and says, that's what it is. And the famous sentence of the social contract, the challenge is to find a form of association, defend and protect with the whole common force the person and goods of each associate, and which each, while uniting himself with all, may still obey himself alone and remain as free as before. So that's the challenge, how to answer it. Well, my argument, influenced by a number of people like Chiara Cordelli and Anna Stilts, has been to sort of say there's a kind of Kantian argument which takes up that challenge, because Kant accepts the, along with Rousseau, he accepts the Hobbes' need for sovereignty. That's something which recent scholars of Kant have wanted to emphasize. But he also takes from Rousseau the need to do it in a way which satisfies a basic legitimacy demand. And so he agrees it can only happen in a system which one could conceive of not as involving the imposition of the will of one person over another, which is what the Hobbesian sovereign does, but rather if it's somehow the product of our joint will, or the system, not necessarily every piece of legislation that comes out, but the system itself could be characterized as one which has this quality. It's one that we could all accept. And my kind of case is that such a system is actually a democratic system. And it's there because it combines three qualities. The first is that democracy, and I'll go into a little bit more in the next slide, is a system which is non-dominating. That is, as seen by someone like Philip Pettit, we should understand the freedom you get through living in a democratic system as being one which does not put us under the will of another. And yet, it's also a system which can produce collective decisions. So it has sovereignty. And I want to say that it does so. It meets that first non-dominating criterion in the sense that it involves us making, on an equal basis, collective rules which of a general kind which can apply equally to us all, that we subject them ourselves to them in the way defined by Kant at the bottom there. And so, as I've said, the notion here is that the system is one that one could conceive of as the product of an omnilateral will. It does not require consensus as your decision-making rule. And that the system is non-dominating because there's no imbalance of power. The process is neutral and impartial and gives, with everyone having an equal status. It's not personal dependence. It's not the dependence, yes, we all have to abide by rules that have been collectively made, including those that we disagree with. But that's not consistent dependence to a personal ruler. It's not a personal form. And it's not an arbitrary system because it's a deliberative system in the way it works. And no person can consistently operate against another. And so, as I see it, it is majoritarian democracy, that being the rule within such a system. It's unsurprising that one finds that this is correlated with rights protection, because it's a system which forces people to consider each other's ruling in various ways. Now, I don't put this here, but in the chapter that follows, I talk about how does one institute a system of political equality. What's the best way of doing it? And one of the features I particularly discuss in that chapter is why you need a system of proportional representation, because equality between people at the electoral stage has got to be one where they have choices which reflect their preferences to choose between, and B, one where the legislature is likewise treating those preferences equally, because they're represented in proportion to how they manifest themselves at the electoral stage. So I'm assuming that in some sense what we have at present in many countries, Canada and the UK amongst them, is tyranny of a minority because of our plurality political electoral systems. But I think one gets round that with a PR system. So one requires a system where, and for that to be true, you need units, political units, where people really are independent, have an equal stake, and conceive of themselves as a public. And I believe that also works at the international level, and my work on the EU, to which Jacob referred, is a way to try and show that you can extend this argument to thinking about international law and its democratic qualities, as well as domestic law. So my argument so far has been that you need to establish a form of the rule of law that instantiates a rightful condition among individuals, and that depends upon democracy being there. Now, I'm going to say a little bit about how this applies in a sort of real political system, namely something like the Westminster system that you have in Canada and also obviously in the UK. Because so the system feeds into something like parliamentary sovereignty. And yet many people, another Cambridge political theorist, Trevor Allen, has said it's ultimately impossible to reconcile the rule of law with the unlimited sovereignty of Parliament. So since I think a Parliament, or at least a Parliament which operated under PR, would be one which would rightfully be the sort of way that one would reconcile the rule of law and democracy, I feel I need to answer this commonly made objection. And the person to go to for this is obviously Dicey, who's normally seen as the theorist of parliamentary sovereignty. But in chapter 13 of the Law of the Constitution, he has a chapter on parliamentary sovereignty and the rule of law. And why is it that he thinks that the two go together as he does? Well, he does so because he argues that the executive always has to act through Parliament and through parliamentary legislation. And that means that it can't be a system of arbitrary will, because there is this formal process which ensures that there is a debate and the need to get a vote, which binds the executive, and these are then impartially, to the extent that these laws are then applied regularly by the courts, ensures that parliamentary sovereignty is actually a condition for the rule of law. He often compares Britain to France, and argues how France doesn't have the rule of law at this time, because, if Louis XVI wanted to send you to prison, to the Bastille, he could, on a whim, just do it, because the law was what he declared. And so he says, no, we don't have that. We have this processual democratic system, and it's that which is the basis of our rule of law. And my argument, my general argument in the book as a whole, but also in this chapter, is that the basis of your legal constitution having desirable qualities inheres in it being embedded in a democratic system, which has as its inherent elements those qualities that you look for in your constitution. So obviously there are many critiques that may be made, and if you're interested in reading the paper, I have the critiques of Habermas, Dworkin, and Hayek there to look at. Have I got 5 minutes more, or not? So in my 5 minutes more, I will just talk about one of them, because in some ways, Habermas might seem to be the more challenging critic, because in certain respects, his argument is quite similar to mine, in that he argues that the rule of law and popular sovereignty are, if you like, co-generative. They're co-equal, but I think that the way in which he tries to argue for that is misplaced, because he wants to sort of say, well, they're co-original because you need to frame a democratic, what makes a democratic system legitimate is that it's conducive to producing the right answer. But that suggests that you have an understanding of what the right answer is in order to design your political system. And then say, and he would say the rule of law is the rule of the procedural rules which define the right answer. But he says that at the same time as admitting that the very reason why we need a political system in the first place is because we don't know what the right answer is. So that can't be the right way of conceiving of this relationship. Whereas my way I've tried to conceive of it is simply by a procedural element, that the system itself meets a condition of non-domination through involving respect for all as equal moral reasoners. So I think that is distinct from his kind of argument. I think he goes too far in the way he puts it. And then finally, because I've given you this slide after slide of dead white males, with the exception of this alive white male, I do want to sort of say it isn't, as I did mention at one point, I have been influenced by Annie Stiltz and Chiara Cordelli in much of my argumentation. And I think there's a certain similarity so far as my sort of EU international aspect with the work of Adam Getteschauer. I've just adopted the same philosophers, indeed, that Stiltz and Cordelli draw in, which are Rousseau and Kant in my argumentation. So that's it, really. I've tried to argue the rule of law is impossible to have without the rule of persons, not simply in the trivial sense that law is a human artifact, but also in the sense that if you want law to have the sorts of qualities which we consider as being appropriate in terms of consistency and coherence, etc., then the only kind of system which has an inbuilt incentive to see them in this way is a democratic system. So, thank you.
My microphone isn't working. I'll ask that people use it. Use the microphones at their own seats. At these events, the first question is reserved for a member of the RGCS Charles Taylor Student Fellowship. Apparently you have to turn your microphone
Right.
each time in order for other people to turn.
Hi, my name is Thu. Thank you so much for the talk. It's really great. And I'm really interested in the aspect, because you also brought in Getachew. And that was exactly what I was going to ask you, because I know international law question mark. And I was wondering if you can elaborate more on the extension to international law, since, as we've known, like sovereignty often limits itself within territorial borders. And international law seems to work with state and not persons, except for international human rights law. So I was just curious to your extension on that. Thank you.
Right. So, so I think that if one sees international law as law which is made between states, I mean, one of the difficulties one has is that not all states are currently democratic. So one needs somehow to facilitate that and give incentives in the system. But when one looks at systems where the members of these bodies are all nearly democratic, shall we say, you know, including so the bodies that I've particularly studied are the European Council and Convention on Human Rights and the European Union. My argument is that those have proven capable of creating, for example, in the case of the EU, a status of European citizenship, which is you know, an agreement between states, which nonetheless involves a system of mutual respect for their different systems. So, you know, European citizenship notoriously is not linked to the creation of a European state, as it were. What it means, you know, I worked for quite some time in Italy. I was able to do so without becoming an Italian citizen, but I had certain rights not to be discriminated against on the basis of my nationality, in particular. And so, you know, something which I have now lost. So it's, so I see those sorts of arguments as being ways in which you should understand it, that there are good reasons why states want to have free movement between their countries and engage in trade which is mutually respectful. And so I'm in favor of setting up institutions which enable them to bargain between, but it's what I call a two-level form of democracy. It's democracy within states and then democracy between states that creates that, rather than some kind of global democracy system. And I see that as being one which, yeah, will produce a broad and fairly rich system, whilst preventing the upper level becoming dominating in itself. And I suppose some of my arguments there were governed by the worries that the EU itself can become a dominator. For example, in the way in which, in the wake of the financial crisis, it imposed austerity on a number of other states. So in that sense, I'm also agree with the person you said was your most popular lecturer, in her book on the EU. It's quite a similar argument. Yeah.
Hello, Professor. I'll just talk. First, I'd like to thank you for your lecture. I thought it was very, very insightful. My question pertains to what extent you might have engaged with, I recognize you've engaged with Hobbes and talked about the sovereign. I'm curious to what extent you've engaged with Plato and what he talks about with an aristocracy and the rule of the best. In that sense, do you think there's any way, even in a theoretical sense, in which the rule of law could be upheld if there was an aristocracy, say the rule of the best, in the sense that Plato imagined it? Thank you.
In the written version of this chapter, I do deal in part with those who obviously suggest that the rule of law is upheld in particular by the rule of judges, who may not be Platonic guardians. Dworkin in particular is very insistent on that. But the notion is, nonetheless, they have a training and certain legal constraints that will move them in this direction. So it's not per se an epistocratic argument, something I also criticize in the chapter that follows. But and I suppose my argument is that the judiciary do not necessarily have adequate incentives to be impartial and treat all points of view equally in making their determinations. And that even with the best will, even if you have a group of very well disposed people, should we say, both knowledgeable and well disposed people, as I think the judiciaries of many countries are, nonetheless, they will be partial in the sense they'll be partial because they only have limited experience and knowledge. They can't. And one aspect of democracy is that it's a mechanism for gathering dispersed knowledge together. And in particular, knowledge of how individuals in different ways and different perspectives might be harmed by a particular determination. Moreover, it's one that they can relate to as being theirs. The law can seem theirs then. So I think that these are reasons why I believe that the democratic system is going to be superior in its legitimacy to an elite guardianship argument, be it the moderate one of judges or the full-blown Platonic epistocratic argument.
Please. So I guess my question is, I just have a question about the alternative form of
Hi, thank you for the talk. My question is more of a clarification question, I think. Is the main thesis, the sort of via media that you want to navigate, is the main thesis, am I understanding it correctly if I think of it as an empirical hypothesis? In other words, is your argument an instrumental one, which says that democracy, however you conceive it, is an instrumentally necessary or conducive condition to the rule of law, or is that a mischaracterization of your position?
That is indeed part of what I'm saying, but I'm also saying that it has these instrumental qualities because there's also an intrinsic relationship between them, that a democratic system which is non-dominating has rule of law-like qualities to its processes as well as the products that it produces.
Is that intrinsic feature of democracy necessary for there to be the rule of law? So it's one thing to say that in democracy there's rule of law, but it's different to say that in the rule of law there's democracy. Is that also something you want to say intrinsically?
In democracy, as I've conceived it, yes, because otherwise I think there are dangers, in particular instantiations of democratic systems, those which regularly empower a minority, for example, that will allow for arbitrary decisions which are inconsistent, therefore, with the rule of law, because the rule of law has as its quality that it sort of modifies or constrains arbitrariness. And so that's my objection to Raz's view, because I think that a tyranny has no constraint on arbitrariness in the way it interprets the law or whether it abides by it or not. So I think that a non-dominating democratic system has that inbuilt constraint on arbitrariness, and that's important for consistently having the rule of law.
Hello. Would you argue that therefore, in the context of democracy, the procedural aspect of the rule of law, i.e. like how the law is set about and the lack of arbitrariness, the fact that it has to go through a parliament, for example, etc., is more important than the substantiveness of the laws for there to be democracy?
Yeah, I have a procedural, I emphasize the procedural qualities. So the rule of law, so a virtue of acceptance of the laws that come out from a democracy, even though you disagree with the substantive content, is that you're accepting of how the law has been made, even if you remain critical of what has been decided.
Thanks for the talk. So I suspect that you might answer in one way, but I want to see what you're going to say. So it's easy to say that democracy, or to frame democracy as being inclusive, right? But in practice, there are various issues about inclusion regarding democracy. We can conceive of Herrenfolk democracy, or white supremacy democracy, where the people is understood in racial terms, and where laws are made through all of these features associated with democracy in a way that could guarantee the rule of law for the people, to the extent that the people is understood as being restricted to a racial group. So, admitting this, do you consider that in such a place, the rule of law applies to certain groups and not to others, or is it a failure of the rule of law? Or even further, what I suspect you would say would be that it's a failure of democracy.
Will be a failure of both, because, well, those who are excluded are placed in the position of, they're in the state of nature with regard to the polity which is excluding them. So, so that would be a reason for objecting to it. And indeed, one of the reasons why I also am concerned about international systems, including international systems which produce human rights for individuals, is that, yeah, I want it to include those who find themselves caught between states, for example, who often, as we know, are precisely in the position that you've just described. So I want there to be mechanisms which deal with such situations, democratic mechanisms.
Great. Thanks so much for the stimulating talk. I have a question about how you would respond to the Razian argument. I just want to hear a little bit more of that. So if how I'm understanding the dialectic thus far is you're arguing that we cannot have the rule of law without the democratic rule of persons, to which somebody like Raz responds and says, well, non-democratic states have legal systems that respect the rule of law, so therefore we can have the rule of law without the democratic rule of persons. And then the sort of way to save this is to say that built into the democratic rule of persons is the concept of the rule of law, and then from that we're going to have this idea that there's this like non-dominating characteristic within democracy. And that seems to work at like a certain level of idealization, but I'm just wondering about real-world democracies that aren't that ideal, right? So it's very rare that real-world democracies meet this sort of like non-dominating characteristic. They're certainly not over here on the side of the tyrannies, right? But is the rule of law ever like instantiated in legal systems and real-world democracies that aren't perfectly non-dominating, that don't fit the other sort of laundry list of conditions that we would like to have in the idealized account, right? Thanks.
No, I mean, nowhere ever fits the ideals of either the democratic school or the legal school. But if one's seeking to deal with the inevitable imperfections of the legal system, then it's only can be done through political action. And if we're disappointed with the legal system that we have, ultimately that also will require political action to improve it. I mean, it's true that, say you have there are elements in your legal system to which you could appeal. But again, if those appeals are going to be heard, it'll be through the political system that they ultimately are heard. So, so the whole argument that I have, in the book, is that it's the primacy of the political, basically, and that ultimately your legal constitution will only be as good as your political constitution. So, in that sense, I think advocates of militant democracy, which is really militant constitutional law, have got it wrong. It's the wrong way round. You really do need militant democracy in order to improve the constitution that exists, not militant appeals to entrenching certain features. So, yeah.
I'm going to ask the last question from here before moving up to the podium to bring us through to conclusion. On page 48 of Political Constitutionalism, you say of Canada that the experience of Canada and Britain suggests that legislatures are very reluctant to employ mechanisms like the notwithstanding clause because it places them in a position where it appears they are putting rights to one side. And that means that the notwithstanding clause doesn't adequately constitute, in your sense, a weak form of judicial review that keeps the judiciary in conversation with the democratic branches, but rather creeps toward being strong form or judicial supremacy forms, and therefore you are skeptical even of a notwithstanding clause like constraint on the majoritarian political branches. Now the owl of Minerva flies, you know when it flies, and since 2007 the dam has well and truly broken on the willingness to use the notwithstanding clause, including often being used preemptively. That is to say, the legislatures are increasingly not just reluctant to be seen as coming into conflict with the Federal Charter of Rights and Freedoms, but quite eager to make the point in politically passing the act in the first place that they welcome the accusation that they are coming into conflict with the Charter. And the record of legislation that has been passed, either preemptively under the notwithstanding clause or subsequently under the notwithstanding clause, is not one of great friendliness to minority interests and what a liberal would call minority rights in the various provinces affected. In a way, this is like Arash's question, how much of the argument depends on empirical propositions and generalizations? Does it matter for your argument if it turns out that after everyone gets used to the notwithstanding clause, it becomes an ordinary piece of politics? Also, does it matter for your purposes what kinds of laws tend to be passed pursuant to it?
Thank you for that. I mean, well, one of the things which has changed between that book and the one that I'm hoping will be published sometime next year is that I think when I was writing that, although the Human Rights Act was published by that point, much of my thinking about it had been before the human rights came into force, and when I was a little bit skeptical of having it. So, but then I did subsequently write an article on defending the Human Rights Act from my political constitutionalist perspective, as I also wrote a piece on the European Convention of Human Rights from that, both of which I've incorporated in revised form in this book. So one of the reasons why I supported those was because both of them have, both the domestic and the European conventions have been increasingly attacked by conservative governments which have had in their manifestos commitments to repeal both, which so far hasn't happened. So from an ideal perspective, my position is that I think weak review is good, and it's good for one thing, that laws are necessarily general in character, and what courts see is a particular individual, and they can then ask the question, is there a danger of an injustice, a processual injustice to this individual in the way in which, by the virtue of this legislation? And I think that the mechanism which is brought into being by the Human Rights Act, which I think doesn't exist in Canada, is that there's a pre-legislative phase where they actually have to go through all the ways in which it could or could not infringe the Human Rights Act. So one positive version of this, which I look at, is in the UK, unlike Canada, the idea of rape shield legislation was brought about by Parliament, not as a result of a judicial decision. And indeed, a judicial decision instead questioned whether this was being fair to an individual. And the legislature answered, and this would be a kind of model way of doing it in this particular case, by saying, well, we're aware that it's in the nature of things that if we have this legislation, that might mean that an innocent man gets convicted. But we feel the danger lies overwhelmingly on the other side, that at present the lack of this legislation leads to a huge reluctance in many women to come forward, with the result that the many guilty men remain around as sexual predators, etc. So, and I think maybe that balancing is something which is right for the legislature to do better. It's better placed to have the legitimacy to do that. But yes, I mean, of course, any system can be abused. I do think, I was talking with Monique about this before, that I mean, the way in which it was abused under the last administration was with the wonderfully named Illegal Immigration Act, where which involved sending people to Rwanda, where all of the human rights bodies within the parliament were agreed that, as had the court determined, that Rwanda was not a human rights compliant place to send people. In particular, there was the danger that they would be sent back to the country that they were fleeing. And that was clearly against all of the international asylum treaties, etc., that the UK had resolved. I think I take some hope that the first piece of legislation repealed by the incoming Labour government was that piece of legislation, and which had got round all of these objections by saying that it was illegal to ask for a judicial assessment of this very question, which, I think that's worse than a notwithstanding clause. That's sort of saying we're not going to be regularly embarrassed by this issue being discussed. But yes, I mean, no system is perfect, unfortunately, and I think I want to put my faith in human beings being perhaps better than we often are, but I think if we're put in a position where we can answer to the better angels of our nature, then it's it's more likely to happen.